to our channel Law and GK. Here we discuss the previous year paper of judiciary exams and other legal exams. In our previous videos, we have discussed the judiciary exams of Haryana, Uttarakhand, Rajasthan, and currently our Delhi Judiciary previous exam series is going on. And today we are going to discuss Delhi Judiciary exam of 2010. And if you like this video, then please hit the like button and subscribe to our channel. So without any further delay, let's come to the question number 1. That no person accused of an offence shall be compelled to be a witness against himself is a directive principle which the state should apply while enacting criminal laws, human right under the Universal Declaration of Human Rights to which India is a party, fundamental right or ordinary constitutional right. It is a fundamental right. Option C is the correct answer, and it is mentioned where? Under Article 20, Clause 3. Now come to question number 2. The directive principle of a state policy are fundamental for the upliftment of a backward class, protection of the individual rights, administration of justice or governance of the state. It is option number D, governance of the state, and it is mentioned where? Under Article 37 of Constitution Act. Now question number 3. When a writ is issued to an inferior court or tribunal on the grounds of exceeding its jurisdiction or acting contrary to the rules of natural justice, it is called a writ of certiorari, mandamus, quo warranto, habeas corpus. It is a writ of certiorari. Question number 4. Consider the following statements. The president can commute death sentence to life imprisonment. The governor cannot commute the death sentence to life imprisonment. The president's power to pardon extends to punishments or sentences by court martial. Which one of the statements given above is correct? Only 2, 1 and 3, 1, 2 and 3, or 2 and 3? First of all, the first statement is the president can commute the death sentence to life imprisonment. Yes, it is correct. And it is mentioned where? Under Article 72, Clause 3. The governor cannot commute. This one is a wrong statement because the governor can also commute the death sentence to life imprisonment. Now come to the third statement, that the president's power to pardon extends to punishment or sentences by court martial. Yes, it is also correct statement, and it is mentioned under Article 72, Clause 1, Subclause B. So the right answer is what? Option number B. Now come to question number 5. Which one of the following is the correct statement? Double jeopardy. Double jeopardy in Constitution, where we read double jeopardy, it is under Article 20, Clause 2 of the Constitution. Trying 2 or more persons jointly for the same offence, trying the same person for 2 offences at 2 different times, putting the same person on trial twice for the same offence, or trying a person for 2 offences committed by him in one incident. It is option number C, putting the same person on trial twice for the same offence. Right answer is option number C, putting the same person on trial twice for the same offence. Come to question number 6. In case of inconsistency between the laws made by Parliament and the laws made by the state legislature, which one of the following shall prevail? The law made by the Parliament before the law made by the legislature of the state, or the law made by the Parliament before or after the law made by the legislature of the state, or the law made by the legislature of the state? The right answer is what? It is option number C, either after or before the law made by the legislature of state. And it is mentioned where? It is mentioned under Article 254. Come to question number 7. Here assertions and reasons are given. So the assertion is the rule making power of the Supreme Court is not subject to any law made by the Parliament of India. And its reasoning given is only an impartial and independent judiciary can protect the rights of the individual. So the assertion is basically in Article 145 of the Constitution, which says that it is subject to the law made by the Parliament. And here it is mentioned that Supreme Court is not subject to made by the Parliament. So the assertion itself is a wrong statement. So here the right answer will be A is false but R is true. Option D is the correct answer. Now question number 8. Assertion is the entries in the 3 legislative lists are not always set out with scientific precision. And the reason is the entries are not powers but only fields of legislation. So both these statements are true actually but are not related So the right answer is option number B. Are individually true, but R is not the correct explanation of A. Now come to question number 9. Consider the following statements. The Supreme Court has original jurisdiction in any dispute between the government of India and one or more state. Yes, this one is correct statement and it is mentioned under Article 131. Next statement, the Supreme Court has original jurisdiction in any dispute between the government of India and any state or states on one side and one or more other state on the other side. Yes, this is also correct statement. Now third statement, the Supreme Court has original jurisdiction in any dispute between government of India and any corporation of individual on one side and one or more states on the other. No, this is not mentioned. Okay, so this is not a correct statement. And what is the fourth statement? The Supreme Court has original jurisdiction in any dispute between two or more states. Yes, this is also correct. The right answer will be what? It is option number B, 1, 2 and 4. These all are examples of original jurisdiction of Supreme Court under Article 131. Now come to question number 10. Consider the following statements. The High Court has jurisdiction to punish for its contempt, tender advice on the legal question referred to it by the governor of the state, tender advice on a legal question referred to it by the governor of state, issue certain writs for enforcement of fundamental rights or for other purposes. The High Court has jurisdiction to punish for its contempt and it is mentioned where? Under Article 215, contempt. And tender advice on legal question? No. And then fourth is issue certain writs for enforcement of fundamental rights or other purposes. Yes, this is also a correct statement. And High Court can issue writs on fundamental rights under which article? 226, article number 226. So the right answer is option number 1 and 4. A is the right answer, option A. Now question number 11. Which of the following is not an essential ingredient of a valid arbitration agreement? Actually, the same question is asked in the year 2014 also in Delhi Judiciary. So it is a kind of important question. Let's come to the options. The parties must addendum. There should be an animus arbitrandi. The agreement must be in writing. The agreement must be registered. So not an essential ingredient is that the agreement must be registered. Option number D. Because registrations is not necessary. Section number 7 to Arbitration Act. And what is the meaning of addendum? Addendum means meeting of minds. And what is the meaning of animus arbitrandi? Animus arbitrandi means that there should be an intention of referring the dispute to arbitration. Now come to question number 12. An arbitration agreement must relate to present dispute, past disputes, present or future disputes, or all of the above. Well, it must relate to all of the above, means present, past or even future disputes, and it is mentioned where? Under section 7 of the act. Now come to question number 13. Which of the following is the material difference between an arbitration agreement and an ordinary contract? In ordinary contract, the obligation of the parties to each other cannot in general be specifically enforced and the breach of them results only in damages. Option B is the appropriate remedy for the breach of agreement to arbitrate is not damages but its enforcement. Option number C is both A and B are correct and D is both are incorrect. The right answer is what? Option number C. Both A and B are correct statements. Even not only the remedy but also damages can be claimed. Now come to question number 14. Mark the correct statement with reference to Arbitration and Conciliation Act 1996. There is no provision where the party can apply to the court for reference to the arbitration in respect of the matter which is covered in arbitration agreement. The court can only refer the matter to arbitration when the matter is pending before it. Even if the judicial authority is seized of the matter, the arbitration proceedings may commence or continue and an arbitral award may be made. Or option D, all of the above. The right answer is what? All of the above. The court can only refer the matter to arbitration when the matter is pending before it. It is section 8 of Arbitration and Conciliation Act. Now come to question number 15. Under Arbitration and Conciliation Act 1996, the presiding arbitrator replaces the umpire of the old act. The presiding arbitrator is a part or and parcel of the arbitral tribunal, while the umpire under the old act was the third person. Option C is presiding arbitrator makes award along with the panel of arbitrators, while umpire could make award single-handedly when the appointed arbitrators had failed to arrive at consensus. And option D is all are correct. So basically here in this question, it is a comparison with the old act of 1940. So the right answer is that all three are correct one. So right answer is option number D, all are correct. Now come to question number 16. Under the Arbitration and Conciliation Act 1996, the mandate of arbitral tribunal terminates what? When the arbitrator withdraws from office, the parties agree to terminate his mandate. Incompetency of the arbitrator, or all of the above? This one is also all of the above and mentioned in section 14 of the Arbitration and Conciliation Act. Now come to question number 17. The whole arbitration jurisprudence centers around the freedom of the parties to agree, the freedom of parties to disagree, the freedom of parties to move court for enforcement of a word, or freedom of parties to move court for setting aside an award. It is the freedom of the parties to agree. Option number 1, A, is the correct answer. Question 18. In which case Supreme Court held that the power to grant interim measures under section 9 of the Arbitration Conciliation Act extends to international arbitration as well? The case was Bhatia International versus Bulk Trading. Option A is the correct answer. Now come to question number 19. Which of the following statements is correct? Unless otherwise agreed by the parties, the conciliator shall not act as an arbitrator. Unless otherwise agreed by the parties, the conciliator shall not act as a representative or counsel of the party in any arbitral or judicial proceedings in respect of a dispute that is the subject of the conciliation proceedings. Option C, unless otherwise agreed by the parties, conciliator shall not be presented by the party as a witness in any arbitral or judicial proceedings, or all of the above? Well, conciliation is what? Conciliation is part 3 of the act, and this is both these options are from section 80, clause A, and option C is from clause B. These options are from clause A and C. Option C is from clause B. So right answer is option number D. Now come to question number 20. In which case the Supreme Court held that under section 34 of the Arbitration and Conciliation Act 1996, the court can examine the validity of international awards? The case was Oil and Natural Gas Corporation Limited versus Saw Pipes Limited. Option number A is the correct answer. Question 21. In which of the following cases a partnership exists? Several persons jointly purchase goods for resale with a view to dividing the profits arising from the transaction. Or option B, persons co-owners who join in purchase of goods for the purpose of dividing the goods themselves. ABC agreed that each should furnish rupees 3,000 worth of goods to be shipped on a joint venture, the profits to be divided among them according to the amount of their several shipments. Or option D, two tenants in common of a house let it and divide the rent equally. So the partnership will exist in the option number A. Several persons jointly purchase goods for resale with a view of dividing the profits arising from the transaction. Come to question number 22. In which of the following cases a partnership does not exist? Lender of money receiving profits, servants or agent receiving profits, a widow or a child of a deceased partner receiving profits, or seller of goodwill receiving profit? It is all of the above. Option number D is the right answer. Question number 23. A and B entered into an agreement which described them as partners. The agreement provided that in lieu of his share of profits, B was to receive rupees 500 per month and was not responsible for any loss or liability of the firm. Later, a dispute arose between the two. B contended that he was not a partner since there was no agreement to share the profits of business. So, which is the correct answer? That B is a salaried partner. Option C is the correct answer. Come to question number 24. A partner cannot contract himself out of which of the following duties? Duty of utmost good faith, uberrimae fidei. Option number 2, duty to carry on business to the greatest common advantage, duty to render true accounts and full information, duty to indemnify for the fraud, indemnify for willful neglect, and duty to properly use the firm's property. The right answer is option number A. Come to question 25. The authority of a partner to bind the firm by his acts done in the usual course of business is called his implied authority. Such authority does not include selling the firm's goods to borrow in a trading firm, settling accounts with the persons dealing with the firm, withdraw a suit or proceeding filed on the firm's behalf. It is option number D. Withdraw a suit or proceeding filed on the firm's behalf. Section 19. Come to question number 26. A notice to a partner operates as a notice to the whole firm. However, for that, the notice must have been given to a partner who habitually acts in the business of the firm. Notice to a dormant or sleeping partner would also suffice. Notice to a partner who commits a fraud on the firm will not be a notice to the firm. Option both A and C are correct. The right answer is option number D. Both A are correct. Come to question number 27. In which of the following cases a firm will not be liable for the wrongful act or omission of a partner? Option A is partner of a firm while acting in ordinary course of business colluded with the partner of another firm causing loss to other firm. Option B is a partner acting within the scope of his implied authority raised money by drawing bills in a fictitious name and he used the money in the firm's business. Option C is a receipt of the money due to the firm by one of the partners by way of a set-off against his personal debt to the other party, or option D is none of the above. Well, the right answer is option number C, receipt of money due to firm by one of the partners by way of set-off against his personal debt to other party. Now come to question number 28. According to section 30 of Partnership Act, at any time within 6 months of his attaining majority or obtaining knowledge that he had been admitted to the benefits of the partnership, whichever date is later, a minor can elect to become or not to become a partner. Such option is exercised by giving a public notice. Yes. If he remains silent and fails to give such a notice, then there is a presumption that he wants to be a partner, and on expiry of the said 6 months, he shall become partner of the firm. If he did not exercise the option, he will be deemed to become a partner in the firm. And these all are correct. The right answer is option number D. All are correct. Come to question number 29. A, B and C are partners in a firm. C retires and X is admitted as a new partner. The firm did not give public notice of the change but continued its business in its old firm name. Z, a customer of the firm, deals with the firm after the change and the firm becomes indebted to him. Now, Z can sue ABC and X, or Z can sue ABC. Z can sue either A, B and C, or A, B and X, and Z can sue A and B only. This question is actually repeated in 2011 also. The right answer here is option number C, that Z can sue A, B and C, or A, B and X. It's up to Z. Now question number 30. The right to rescind the contract of partnership is an absolute one and cannot be lost. Is lost if the contract is not repudiated within a reasonable time of discovery of fraud. Is lost if the contract is not repudiated within 1 year of discovery of fraud. Is lost if the contract is not repudiated within 3 years of discovery of fraud. It is option number A, absolute right and cannot be lost. Question number 31. Mark the incorrect statement. Law of limitation is bars the judicial remedy, does not extinguish a substantive right, is an adjective of or procedural right, or creates a right in favor of a person. Basically, these are the general principle. The right answer is option number D, creates a right in favor of a person. This is a general principle. Now come to question number 32. Mark the correct statement. A debt does not cease to exist only because its recovery is barred by the statute of limitations. A defendant can plead that the instrument is voidable even if his suit to set aside on the ground of its voidability is barred by limitation. Both A and B, and none of the above. It is option C, both A and B. Question 33. Good faith under Limitation Act implies due care and attention. It becomes relevant when the question is whether the limitation period should be extended or not, the delay on the part of a party should be condoned or not, both A and B, or none of the above. It is option number C, both A and B. Question 34. Period of limitation means that the period of limitation prescribed for any suit appeal application by the schedule to the Limitation Act. Period of limitation means option number A. This is the right answer. Actually, this is the definition 2J of Limitation Act. And the option number B, the period of limitation computed in accordance with the provisions of the Limitation Act. Actually, this is also a correct statement, and this is a definition of the prescribed period under 2J. Question number 35. A party who prays for condonation of delay under Section 5 of Limitation Act 1963 has to establish that he is vigilant, no negligence on his part, no lack of bona fide on his part or all of the above? It is all of the above, and this is a conceptual based question, that he should be vigilant and not negligent, and there is no lack of bona fide on his part. Now come to question number 36. Section 6 of Limitation Act lays down that where a person entitled to institute a suit etc. is at the time from which the prescribed period is to be reckoned a minor or insane or an idiot, he may institute the suit etc. within the same period after the disability has ceased as would otherwise have been allowed from the time specified in the schedule. So section 6 does not provide for fresh starting point of limitation, and section 6 does not prevent the running of limitation but only extends the period of limitation. Both these statements are correct. The right answer is option number C. Both A and B are correct, and section is section 6 only. Now question number 37. Where a person is affected by two legal disabilities or where one disability followed by the another without leaving a gap, then the suit or application may be filed till the first disability ceases to exist, till the second disability ceases to exist, after both the disabilities have ceased. It is option number C. Both disabilities have ceased, and it is mentioned where? Under section 6(2) of Limitation Act. Now come to question number 38. If a pro note is executed on 5th June 1945, the last day for filing of the suit will be what? It is executed on 5th June 1945. So the day on which cause of action arises shall be excluded according to section 12 subsection 1. So the counting will be start from 6th June to 5th June, and 3 years from that, then the right answer will be 5th June 1948. Option number A is the correct answer. 5th June 1948. Now come to question number 39. Which of the following is not an essential requisite of a valid acknowledgement? It must be made before the expiration of limitation period. It need not be in writing. It must be signed by the person making the acknowledgement or by his duly authorized agent, or it must be made by a party against whom any property or a right is claimed or some person through whom he derives title or liability. So which is not an essential requisite? It need not be in writing. Option B, because it should be in writing, and it is section 18, valid acknowledgement. Now come to question number 40. In a suit filed by the plaintiff, the defendant in his written statement has taken the objection of non-impediment of necessary part. Despite such objection, the plaintiff continued the suit and the suit finally was decreed. At the first appellate stage, the plaintiff withdraws the suit with liberty to file a fresh one on the same cause of action and subsequently filed a fresh suit. The period spent by the plaintiff in the earlier suit under section 14 of the Limitation Act is liable to be excluded on the ground that the plaintiff was prosecuting the earlier suit with due diligence and in good faith. Option A is the correct answer, and it is mentioned where? Under section 14 of the Limitation Act. Now come to question number 41. Which of the following contracts cannot be specifically enforced? A contract to sell to B a certain number of railway shares of a particular description and A refuses to complete the sale. Option B, A holds certain stocks in trust of B and A wrongfully disposes of the stock. Option C, A is a trustee of the land and with power to seize for 7 years, and he enters into a contract with B to grant a lease of the land for 7 years with a covenant to renew the lease at the expiry of the term. Or option D, all of the above. It is actually answer number option number C and section 14 of SRA. Now come to question number 42. Which of the following is correct? A, contract to sell certain land to B for rupees 5,000. A afterward conveys the land for 6,000 to C, who has notice of the original contract. B may refuse the specific performance of contract as against C. This is the actually correct statement. Now B, A contract to sell land to B for 5,000. B takes possession of the land. Afterward, A sells it to C for 6,000. C makes no inquiry of B relating to his interest in land. B's possession is sufficient to affect C with notice of interest, and he may enforce a specific performance of the contract against C. This is also correct statement. So the right answer will be option number C, both A and B. Now come to question number 43. A contracts with B to sing for 12 months at B's theatre and not to sing in public elsewhere. Option A, B cannot obtain specific performance to sing, but he is entitled to an injunction restraining A from singing at any other place of public entertainment. Or option B, B can only obtain specific performance to sing. The right answer here is option number A, that B cannot obtain specific performance to sing, but he is entitled to an injunction restraining A from singing. Now come to question number 44. A is B's medical advisor. He demands money from B, which B declines to pay. A then threatens to make known the effect of B's communication to him as patient. Options are: B may obtain a prohibitory injunction to restrain A from so doing. Option B, B may obtain a mandatory injunction ordering A to destroy all written communication made by B as a patient of A. Or option number C, both A and B. And option number D, none of the above. The right answer is both are correct statement. Option C is the correct answer. Now question number 45. Which of the following is incorrect? We have to find an incorrect statement. A person seeking specific performance of a contract must approach the court within reasonable time, even if time is not an essence of the contract. So this is a correct statement. Option number 2 is family agreements means compromises can be specifically enforced. Option C is in a suit for specific performance of a contract, the plaintiff may also claim compensation for its breach, either in addition to or in substitution of such performance. Option D, that there is a bar to decree for specific performance if there is a clause in contract that in the event of its breach of or non-performance a sum of money specified therein is to be paid. So the right answer here is option number D. This is an incorrect statement. Now come to question number 46. Any person suing for specific performance of a contract for the transfer of immovable property may, in an appropriate case, ask for possession or partition and separate possession of property. In addition to such performance, refund of any earnest money or deposit paid or made to him in case of his claim for specific performance is refused. Both A and B or none of the above. It is both A and B. Option C is the correct answer. Now come to question number 47. Under section 6 of SRA, a tenant can file a suit for possession even against the landlord on the ground that he was unlawfully dispossessed by the landlord, or no question of title either of the plaintiff or defendant can be raised or gone into the case. Option C, both are correct, and D, both are incorrect. It is option number C actually. Both are correct statements. Now question number 48. Specific performance of contract to build or repair can be ordered where the plaintiff has a substantial interest in the performance of the contract and he cannot be compensated adequately in damages. The right answer is option number A only, so no need to read out other options. Come to question number 49. A mandatory injunction in the nature is restitutory, prohibitory, both restitutory and prohibitory, and neither one. It is both restitutory and prohibitory. Now question number 50. Injunctions cannot be granted in contract which can be specifically enforced, in contract which cannot be specifically enforced, irrespective of whether the contract is specifically enforceable or not, or either B or C. It is option number B, in contract which cannot be specifically enforced. Now come to question number 51. Whose signature does the 1 rupee note bear? The President, Finance Secretary, the Prime Minister, or the Governor, Reserve Bank of India? It is the Finance Secretary. Option B is the correct answer. Question 52. Deficit financing in India implies expenses are more than money in circulation. Proper ratio of keeping gold for printing notes is not maintained. State's expenditure is more than union government's expenditure, or excess of expenditure over current revenue and non-banking borrowing. Deficit financing is basically expenses are more than the money in circulation. Option A is the correct answer. Next is question number 53. Which organization is popularly called the World Bank? International Monetary Fund, International Bank for Reconstruction and Development, International Development Agency, International Financial Corporation. It is option number B, International Bank for Reconstruction and Development. And where is its headquarter? Its headquarter is in Washington, DC. And who is the president? President is David Malpass. And who is the current managing director of IMF? It is economist Kristalina Georgieva, and she held the post on 1st October 2019. And who is the first deputy managing director of IMF? First deputy. This is also important, that first deputy managing director is Geeta Gopinath. Now come to question number 54. There are two lists given. You have to match both the lists. So in list 1 there are some festivals given, and in the second list the name of the states are mentioned. You have to match that which festival is celebrated in which state. So first one is Pongal. Pongal is celebrated in Tamil Nadu. So Pongal is in Tamil Nadu. First का D है. Now Onam. Onam is celebrated in Kerala. Onam is in Kerala. तो 2 का है, 1 का D, 2 का C. बैसाखी. बैसाखी is in Punjab. So 3 का 2 यानी B. And car festival, it is not car festival, it should be cart festival. It is in Puri. So the right answer will be option number B. Come to question number 55. Which of the following islands is situated in Arabian Sea? In Arabian Sea, Andaman Island, Tokyo, Lakshadweep or Indra Point. It is option number C, Lakshadweep Island. Question 56. Which statement is true? Solar eclipse occurs when moon comes between sun and earth, or solar eclipse occurs when the earth comes between sun and moon, or solar eclipse occurs when the sun comes between earth and moon, and none of the above. Solar eclipse occurs when the moon comes between sun and the earth. So option is A. Question number 57. McMahon line demarcates India and which country? It is India and China. McMahon line is India and China. Question number 58. Again you have to match the two lists. In list 1 there are some certain famous names are given, and in list 2 their famous works are mentioned. You have to match. So Raja Ram Mohan Rai was related to which? Brahmo Samaj. Option 1 D. M.G. Ranade. M.G. Ranade was related to Prarthana Samaj. It is A. Dayanand Saraswati related to Arya Samaj. B. And Swami Vivekanand is Ram Krishna Mission. Right answer will be option number D. Come to question 59. Again two lists, match them. Act of 1858 is related to what? British Crown assumes power. So it is 2. Indian Council Act 1909. It is Minto Morley Reforms. Government of India Act Diarchy. And Government of India Act 1935 is Provincial Autonomy. The right answer will be what? Option number D. Come to question 60. Ozone layer is important because it helps in photosynthesis. It prevents Earth's radiation from escaping. It filters ultraviolet rays selectively, or it blocks ultraviolet rays completely. It is option number C. It filters ultraviolet rays selectively. Now question 61. Veins carry blood away from the heart, towards the brain, or none of the above. It is towards the heart. Option B is the correct answer. Question 62. The planets nearest to the sun are Mercury, Mars, Earth, Mercury, Mercury, Venus, or Mercury, Uranus. It is Mercury and Venus. Option 3 is the correct answer. Question 63. Who is the author of autobiography Wandering in Many Worlds? It is Justice V.R. Krishna Iyer. Option B is the correct answer. Question 64. Who is the Chief Justice of Punjab and Haryana High Court? It is Justice Mukul Mudgil.
This was of the year 2010 and at present it is Justice Ravi Shankar Jha. दिल्ली का पूछ सकते हैं तो अभी एक्टिंग चीफ जस्टिस हैं जस्टिस विपिन सांघी. इन बिटवीन कोई अपॉइंटमेंट हो जाए तो याद कर लेना. एंड बॉम्बे के चीफ इट इज़ जस्टिस दीपांकर दत्ता. एंड हु इज़ द फर्स्ट जज ऑफ दिल्ली हाई कोर्ट? ही वाज जस्टिस K.S. हेगड़े.
Option D is the correct answer. Question 65. Ombudsman refers to the person who looks into the complaints against public authorities, or who is the chief of the gang, who is declined from court process, or who is the retired judge. Ombudsman. It is option A, who looks into the complaints against public authorities. Now question 66. The Supreme Court laid down certain requirements to be followed in all cases of arrest and detention. In which case it was discussed? Arrest and detention. So D.K. Basu's case. Option B is the correct answer. Question 67. The first Justice Prize winner in India who had been named by the International Bar Association as Living Legend of the Law is whom? It is F.S. Nariman, Senior Advocate of Supreme Court. Option A is the correct answer. Question 68. First woman Chief Justice of High Court in India is whom? It is Leela Seth. Option A is the correct answer. And Sarojini Naidu was the first woman governor of India. First woman governor. Now come to question number 69. Who among the following names is associated with drafting of IPC 1860? It is Lord Macaulay. Option A is the correct answer. Question 70. The system of Indian election follows adult franchise, direct election system, mixed vote system, or none of the above. It is adult franchise. Option A is the correct answer. Question 71. LLB stands for what? Lowest jury, legalite lawyers, Bachelli, legum bacheloris, or bachelor of law. It is option C, legum bacheloris. Question 72. Dash is the law of place, national law, less loci, just remedium, or none of the above. It is less loci. Less loci is the law of place. Question 73. Ultra vires is a term used for what? A document corrupted by a virus, beyond the scope of power allowed or granted by a charter or by law, an act authorized by law, or an illegal act. It is option B, beyond the scope of power. Question 74. Right of way is covered under law of easement, right of passage act, contract act, or law of torts. It is law of easement. Option A is the correct answer. Question 75. Statement given is the Reserve Bank of India has directed the banks to refuse fresh loans to major defaulters. Assumptions are the banks may still give loans to the defaulters may repay the earlier loan to get fresh loan, the bank may recover the bad loans through such harsh measures. The right answer is basically none of the above. Option D is the correct answer. Question 76. Statement is all intelligent persons are creative. Assumption is all creative persons are intelligent, and creativity and intelligence go together. It is neither one nor two is implicit. Both are not related. Option D is the correct answer. Question 77. Again two lists are given. You have to match mental state and consequences. Volition. Volition is what? The feeling which prompt the will of the doer. It is first one only. A. Intention. Intention is an operation of will directing an overact. This is intention. So B. Motive. What is motive? Motive is the ultimate object of an act. And what is mens rea? Mens rea is generally an essential element of crime. It is D. The right answer is option number B. Come to question 78. Assertion is an accused person has been guaranteed the right to be informed of the nature and cause of accusation, or the reason is the accused person can get his conviction quashed upon vague and obscure charges. So here the first statement is true, but this is not the correct explanation of statement A. The right answer is option number C. Question 79. An accused person cannot be compelled to give his thumb impression, and reasoning given is an accused person cannot be compelled to be a witness against himself. So this thing is not mentioned, but this thing is mentioned. Right answer will be option C is the correct answer. Question number 80. Which of the following statements is correct? The power of judicial review means the power of the Supreme Court to, option number C, examine constitutional validity of any administrative action as well as legislative provision and strike it down if not found in accordance with the constitutional provisions. Option C is the correct answer. Question 81. Incredible. What is the meaning of incredible? Incredible means unbelievable. Option D is the correct answer. Question 82. Antonym of uncouth. What is the meaning of uncouth? Uncouth is rural. One who is lacking refinement or cultivation or taste, which is common, rough. So basically uncouth is unrefined. So the antonym is urbane. Option A is the correct answer. And what is the meaning of urbane? Urbane is polished or refined. Come to question number 83. Give the meaning of legacy. Legacy means inheritance. Option C is the correct answer. Question 84. Give the meaning of puerile. Puerile means childish. Option C is the correct answer. Question 85. Give the synonym of recuperate means what? To recover. Option D is the correct answer. Question 86. Give the synonym of erudite. Erudite means what? Basically, erudite is someone who is learned or scholarly. So, its meaning is somewhere related to academic. Option B is the correct answer. Come to question number 87. Choose the correct option that gives the meaning of the expression given in bold letters in the sentences below. I felt that it was a tall order to expect Nina to go home alone at 12 in the night. So, right answer is difficult. Option A is the correct answer. Question 88. It was his maiden speech and it was memorable. So, maiden speech is what? First speech. Option D is the correct answer. Question 89. Wait upon means to serve. Option A is the correct answer. Question 90. A past master is a person who knows everything of the past, was perfect in the past but knows nothing now, possesses shallow knowledge, or is thorough in a chosen field. Right answer is option number D. Question number 91. Despite being tried his best to persuade people to give up smoking, he could not attain success. So the right answer is despite trying his best. Being tried his best, no. Despite trying his best. Option D is the correct answer. Come to question number 92. But for your time of helping, we could not have accomplished our goal in such a small time span. But for your timely help. Option A is the correct answer. Question 93. If Indian people are united, this nation can become a source of strength for the entire world. So here no correction is needed. This is a correct statement. So option D is the correct answer. Come to question number 94. It is with a heavy heart that I pen these few lines to condole for you on the death of your beloved mother. So it is condole for you, no. It should be that condole with you in. Option A is the correct answer. Come to question number 95. Please do not give him any food if his temperature will rise. Temperature will rise, nahi. It should be if his temperature rises. Option A is the correct answer. Question number 96 to 100 are related to this passage. You can read out this passage carefully. I will come up to the question answers area. Question number 96 is the greatest contribution of the Greeks was in scientific innovation, geometry, the insistence on the proof, or becoming the world's first tourists and colonizers. It is option B, geometry. Question 97. The Greeks' main interest lay in seeing and conquering the world, making the Mediterranean basin their private preserve, geometry, or finding universal concepts. It is finding universal concepts. D is the correct answer. Question 98. The Greeks were able to give importance to the question why? Because theirs was the first civilization not to be overwhelmingly dominated by the priesthood. Option A is the correct answer. Question 99. The author is surprised by the lack of advances made by the Greeks in temple architecture, simple algebra, geometry, or D, establishing the method of proof in the theory of mathematics. It is simple algebra. Option B is the correct answer. Come to question number 100. The author speculates that the Greeks did not make sufficient advances in certain areas of mathematics because of their clumsy numbering system. Option C is the correct answer. Come to question number 101. Which of the following is not an essential condition for the applicability of the rule of sub judice? Rule of sub judice is mentioned where? It is mentioned under section 10 of CPC. Now come to the options. Option A says that the matter in issue in the subsequent suit must be directly and substantially in issue in the previous suit. Option B, both the suits must be between the same parties or their representatives. Option C is such parties must be litigating under the same title in both the suits. And option D is the subject matter and the cause of action should be the same in both the suits. The right answer should be option D. Now come to question number 102. A alleging that he is the adopted son of X sues B to recover certain property granted to him by X under a deed and forming part of X's estate. The court finds that A is not the adopted son of X, but he is entitled to the property under the deed and a decree is passed for A. The finding that A is not the adopted son of X will be what? It will operate as res judicata in a subsequent suit between A and B. Option B will be the correct answer, and res judicata is mentioned where? It is mentioned under section 11 CPC. Now come to question number 103. In which of the following cases the doctrine of constructive res judicata is not applicable? Doctrine of constructive res judicata is mentioned where? It is mentioned under explanation 4 of section 11, which is res judicata of CPC, constructive res judicata. If you see the option, come to option number B, which says that A sues B for the possession of certain property, alleging that it has come to his share on partition of the joint family property. B's contention that the partition has not taken place is upheld and the suit is dismissed. A subsequent suit was filed by A and against B for partition of joint family property. So the right answer is option number B only. Come to question number 104. You have to mark the incorrect statement. The court must be competent to try the suit at the time of filing of the suit. Subsequent change in value doesn't affect the jurisdiction. Correct. It is the plaintiff's valuation in the plaint that determines the jurisdiction of the court and not the amount for which ultimately the decree may be passed by the court. If the pecuniary jurisdiction of the court is rupees 10,000 and the plaintiff files a suit for accounts and finally the court finds on the taking the account of rupees 15,000 are due, the court is not deprived of its jurisdiction to pass a decree for that amount. Now option D, if the plaintiff undervalues or overvalues the claim for the purpose of choosing the forum, it is not the duty of the court to return it to be filed in the proper suit. Actually, option D is the incorrect statement, and return of plaint is mentioned where? Under order 7 rule 10, return. And it should be that it is not the duty. It is mentioned that it is not the duty. The correct statement should be that it is the duty of the court to return the plaint. So option D is the incorrect statement. Come to question number
105.
X is living in Pune and Y his brother in Mumbai. X wants to file a suit for partition of their joint property situated in Delhi and Bangalore. The suit may be instituted in Delhi only. It may be instituted in Bangalore only. It may be instituted either in Delhi or in Bangalore or none of the above. The right answer is option number C. And it is which section? Section 17 of CPC. Question number 106. Mark the incorrect statement. A suit for accounts of dissolved partnership may be instituted either where the contract of partnership was entered into or where the business of partnership was carried on. Option B, a suit for dissolution of partnership carried on in a foreign country is maintainable in India if the parties are resident there. Option C, the proper forum in the case an ordinary agent is the place where the contract of agency was made or the place where accounts are to be rendered and payment is to be made by the agent, or option 4, none of the above. This is basically conceptual question, and this question is related to order 30, and here the incorrect statement is option number B. Now come to question number 107. When an objection as to non-joinder or misjoinder of the parties is upheld by the court, the court may deal with the matter in controversy as regards the rights and interests of the party actually before it. The court should dismiss the suit. The court may allow the amendment of the plaint, namely striking out the codes. The correct answer should be first and third. Right answer is option number D. And this is conceptual question and it is related to non-joinder misjoinder order 1 of CPC. Now come to question number
108.
Mark the incorrect statement in context of a representative suit. If a person suing or defending does not proceed with due diligence, the court can substitute in his place any person having the same interest in the suit. Option B is the suit can be withdrawn, compromised or abandoned by the plaintiff after notice to all the persons interested. Option C, any decree passed in such a suit is binding on all the person interested. And option D is res judicata is not applicable to such a suit. So option A is basically from Order 1, Rule 8, Sub-Rule 5. And option B is Order 1, Rule 8, Sub-Rule 4. And option C is Order 1, Rule 8, Sub-Rule 6. So the right answer is option D. Res judicata is not applicable to such a suit. This is the incorrect statement. Come to question number 109. In which of the following cases amendment of pleadings could be allowed? Mentioned where? Under Order 6, Rule 17. Could be allowed to introduce a new or inconsistent cause of action, to take away a right of the defendant which has accrued to him by lapse of time, for granting relief on the basis of different approaches to the same facts, or option 4, amendment taking note of subsequent events. The right answer here is option number D, both 3 and 4. Come to question number 110. Where a serving officer delivers or tenders a copy of summons to the defendant personally or to his agent, he must require such person to sign an acknowledgement of service to be endorsed on the original summons. Then the copy of the summons will be delivered to the defendant. The original summons with the defendant's signature thereon will be returned to the court, both A and B. And option D is the original summons with the defendant's signature thereon will be returned to the plaintiff. This is basically a conceptual question which is related to Order 5, and option C will be the correct answer here. The statement given in the question is basically related to Order 5, Rule 16. And the options, both the options, option A and B, both are related to Rule 18 of Order 5. Right answer is option number C, both A and B. Now come to question number 111. No one can be ordered to attend in person to give attendance in a civil suit unless he resides within the local limits of the court's ordinary original jurisdiction, resides outside the local limits of the court's ordinary original jurisdiction, but at a place less than 100 kilometers distance from the courthouse. Option C, both A and B. And option D, none of the above. It is option C, both A and B. And it is which order? Order 16, Rule 19 of CPC. Come to question number 112. Mark the incorrect proposition. Set off is a statutory defense to the plaintiff's action, whereas a counterclaim is a cross action. Where is set off and counterclaim are mentioned? It is Order 8. Next option is option 2 says that set off and counterclaim arises out of the same transaction. Next, the set off should not be barred on the date of the suit, while counterclaim should not be barred on the date of filing of the written statement. Claim for the set off cannot exceed plaintiff's claim, whereas counterclaim can exceed the plaintiff's claim. And fifth is both set off and counterclaim cannot exceed the pecuniary jurisdiction of the court. So this is a conceptual question, and the whole question is related to Rule 6 and 6A of Order 8. Here the right answer will be option number B only. Come to question 113. Mark the correct statement. The questions which are put only to test the credibility of a person will not be allowed as interrogatories, although they may be asked in cross-examination. Interrogatories can be administered only to a party to a suit and not to a witness, whereas cross-examination can be of any person, parties and witness alike. A party filing affidavit in reply to interrogatories can neither cross-examine nor adduce evidence to contradict it, as it is a conclusive proof. And option D is all of the above. This is a conceptual question related to Order 11. And here all the statements are correct, so right answer will be option number D, all of the above. Next is question number 114. A suit may be dismissed under Order 9 of CPC where the summons is not served upon the defendant in consequence of the plaintiff's failure to pay costs for service of summons, where neither the plaintiff nor the defendant appears, where the plaintiff after summons returned unserved fails for 7 days to apply for fresh summons, and where on the date fixed for hearing in a suit only defendant appears and he does not admit the plaintiff's claim. First statement is from Rule 2, Order 9, Rule 2. And option 2 is basically Rule 3 of Order 9. Statement third is Rule 5 of Order 9. And fourth one is Rule 8 from Order 9. So all the statements are correct. Right answer will be all of the above. Now come to question number 115. In a suit for recovery instituted by A against B, despite the summons of a suit having been duly served upon B, he did not appear on the date fixed in the summons. On 1/3/1993, the court consequently on 1/3/93 passed an ex parte order against B and listed the case for 3/4/93 for ex parte evidence of A. Here, B can participate in further proceedings of the case. B can seek setting aside of ex parte order if he is able to show good cause for his non-appearance, and both A and B are correct. It is basically what? Order 9, Rule 13, and both A and B are correct statements. Option C is the correct answer. Come to question number 116. Mark the incorrect statement in relation to Order 23 of CPC. At any time after the institution of suit, the plaintiff may withdraw his suit or abandon part of his claim. If the plaintiff withdraws from a suit without court's permission, he is precluded from instituting a fresh suit against the same defendant in respect of the same subject matter. And statement C is that if the court is satisfied that a suit failed by reason of some formal defect or there are other sufficient grounds, it may allow the withdrawal from the suit. And option D is where there are several plaintiffs, the court can allow one of them to withdraw even if the other co-plaintiff do not consent to such withdrawal. Option D is the correct answer, and it is related to Order 23, Rule 1. Question number 117. Compensatory costs can be imposed if the claim or defense is false or vexatious and subsequently disallowed or withdrawn. If the objection to the false or vexatious claim or defense has been taken by the party at the earliest opportunity. Option C, both are correct, and D, both are incorrect. It is what? It is option number C, both are correct statement, and mentioned where? Section 35A of CPC. Now come to question number 118. Where any party dies after conclusion and before pronouncing of the judgment, the suit shall not abate if the cause of action survives. It will be deemed that the judgment has been pronounced after the death of the party. Right answer is option number B, and it is which order? Order 22, Rule 6 of CPC. Question 119. A relief of injunction may be refused on the ground of laches or acquiescence, applicant has not come with clean hands, where monetary compensation is adequate relief, or all of the above. It is all of the above. Order 39 of CPC, injunctions. Question 120. Where it appears to the court that the elements of an acceptable settlement exist, the court may refer it to arbitration, conciliation, mediation, judicial settlement, including that through Lok Adalat, both A and B, or none of the above. It is both A and B, and it is mentioned where? Under section 89 of CPC. Question 121. Mark the correct statement. Evidence excluded by the Evidence Act is inadmissible even if it seems essential for the ascertainment of the truth. Parties cannot contract themselves out of the provisions of the Act. A court cannot, on the ground of public policy, exclude evidence relevant under this Act. Or option D, all of the above. This is the general principles question, and the right answer should be all of the above. Option D is the correct answer. Question 122. A is accused of a child's murder. The following facts are constructed in the case. An hour before the murder, A went to the place of murder with the child. A alone returned home. Collar of A's shirt found to be blood stained. The evidence which takes into account the above mentioned facts is called direct evidence, circumstantial evidence, real evidence, or secondary evidence. It is circumstantial evidence. Okay. Question number 123. Mark the incorrect statement. The terms relevancy and admissibility are coextensive or interchangeable terms. All admissible evidence is usually relevant, but all relevant evidence is not admissible. Relevancy is the genus of which admissibility is the species. Relevancy and admissibility are neither synonyms nor is the one included in the other. Incorrect statement is statement 1. A is the incorrect statement because they are not coextensive. Come to question number 124. The question is whether A owes B rupees 10,000. The facts that A asked C to lend him money and D said to C, in A's presence and hearing, I advise you not to trust A, for he owes B rupees 10,000, and that A went away without making any answer is a relevant fact, irrelevant fact, fact in issue, or none of the above. It is a relevant fact. Option A is the correct answer, and it is illustration G of section 8 of Evidence Act. Question 125. A and B were prosecuted for conspiracy for bribing a police officer. A came to the police station and offered an inspector packet of currency notes. He told the inspector that B had sent the money as consideration for hushing up the case against him. The offer of money and the accompanying statement made by A were relevant against A only, B only, both A and B, and none of the above. It is a conceptual question basically, and it is related to a case. Case name is Badri Rai versus State of Bihar, and the right answer should be both A and B. Question 126. Admissions by agents. Always admissible in civil proceedings. Admissible in civil proceedings only if the agent has authority to take admissions. Not admissible in criminal proceedings. And both B and C. Admissions by agents is section 18 of Evidence Act, and right answer should be both B and C. Option D is the correct answer. Question 127. Telling his wife that P's wife had called him to receive payments due to him, K leaves his house. After 2 days, his dismembered body is found in a trunk. In P's trial for the murder of K, the statement made by K to his wife is inadmissible, partially admissible, inadmissible as it does not directly relate to K's death, or admissible as it relates to the circumstance of the transaction which resulted in K's death. It is option number D. And this is basically a case which is Pakala Narayan Swamy versus Emperor. Question number 128. If X is charged with Y's murder, which of the following will be the hearsay evidence? Z in his evidence states that I saw X stabbing Y with a knife. Evidence of A that Z told me that he had seen X stabbing Y, both A and B, or none of the above. It is option number B. Evidence of A that Z told me that he has seen X stabbing Y is the hearsay evidence. Now come to question number 129. If on the carbon copies of a letter written on a typewriter, signature have been put on the first letter, then other copies will become what? Will also be primary evidence, which is section 62 Evidence Act, will be secondary evidence, which is section 63 of Evidence Act, will be no evidence, or none of the above. They will become what? Secondary evidence. Option B is the correct answer. Question 130. If no attesting witness can be found, it must be proved that attestation of one attesting witness, at least in his writing, signature of the person executing the document is in the handwriting of that person, both A and B, or none of the above. It is both A and B. Option C. And which section? Section 69 of Evidence Act. Question 131. X sues Y for money due on a bond. The execution of the bond is admitted, but Y says that it was obtained by fraud, which X denies. The burden of proof is on whom? X, Y, the state, or X and Y both? It is on Y. Option A is the correct answer, and it is which section? Burden of proof. Section 102, and this is basically illustration B of that section. Question number 132. In which of the following cases the court may presume under section 114 of Evidence Act that a man in possession of a stolen goods after the theft is either the thief or has received the goods knowing them to be stolen? The first statement is basically illustration A of section 114. And second statement that the judicial and official acts have been regularly performed is illustration E of the same section. And option C that the evidence which could be and is not produced would, if produced, be unfavorable to the person withholding it. Example, the police withholding a piece of evidence. And option D, all of the above. It is option number D, all of the above. Question number 133. Which of the following is an exception to the doctrine of estoppel? Estoppel with section 115 of Evidence Act, where a minor represents fraudulently or otherwise that he is of age and thereby induces another to enter into a contract with him, when true facts are known to both parties, when the representation is against the statute, or all of the above. It is all of the above. Question 134. A intentionally and falsely leads B to believe that certain land belongs to A and thereby induces B to buy and pay for it. The land afterwards becomes the property of A and A seeks to set aside the sale on the ground that at the time of sale he had no title. Option A must not be allowed to prove his want of title. B says that A must be allowed to prove his want of title. C is the court will decide, and none of the above. It is option number A. And which section? Section 115, illustration A. Question 135. A local development authority announced a housing scheme and accepted applications under it. Subsequently, finding that the scheme was in violation of the master plan, cancelled it. Option A. It is free to do so without any shackles of promissory estoppel. It is not free to do so due to promissory estoppel. Option C is it is free to do so without any shackles of promissory estoppel, as there cannot be any estoppel against the government in the exercise of its sovereign, legislative and executive functions. And option D is none of the above. This is basically general principle, and the right answer is option number C. Question 136. Which is the most appropriate definition in relation to the hostile witness? Hostile witness with section 154 of Evidence Act. A hostile witness is option A is one who from the manner in which he gives the evidence shows that he is not desirous of telling the truth to the court. Yes, option A is the correct answer. So no need to read out the other options. Question 137. Confession of a co-accused not required to be on oath and cannot be tested by cross-examination. First statement is no evidence within the meaning of section 3 of Evidence Act and cannot be the foundation of conviction. Statement: the only limited use which can be made of a confession of a co-accused is by way of furnishing an additional reason for believing such other evidences as exists. Statement third is it is a very weak type of evidence and is much weaker even than the evidence of an approver. In the aforesaid proposition, which one is correct? Statement only 2 and 3rd is correct. Question number 138. A disputed handwriting can be proved by calling an expert. Disputed handwriting by calling an expert. Which section? Section 47 of Evidence Act. Option B is by examining a person acquainted with the handwriting of the writer of the questioned document by comparison of the two admitted and disputed, and both these statements are related to which section? Section 73 of Evidence Act. And option D, all of the above. Right answer should be what? Option number D, all of the above. Question 139. Cross-examination of a witness must relate to relevant facts and has to be confined to what the witness testified in the examination in chief. And option B is must relate to relevant facts but need not be confined to what the witness testified in examination in chief. Option B is the correct answer to cross-examination of a witness. Now come to question number 140. After re-examination of a witness, the adverse party has right to further cross-examine the witness afresh in general, has no right to further cross-examine the witness. Option C, right to further cross-examine the witness only when a new matter is introduced in the re-examination. Right answer is what? Option C is the right answer. Re-examination of witness, it is mentioned where? Under section 138 of Evidence Act. Come to question 141. Which of the following is not an essential search procedure under section 100 of CRPC? Joining of the two independent and respectable inhabitants of the locality in the search as witness, signing of search memo by the witness to search, attendance of occupant of the place during the search, signature of the accused on the search list. It is option number D, signature of the accused on the search list, section 100 of CRPC. Question 142. In relation to FIR, which of the following statements is not correct? Option A is it is not a substantive evidence. It merely marks the beginning of the investigation. It cannot be used as a previous statement for any purpose. And option D is the informant need not be an eyewitness. Option C is the incorrect statement because it is said that it cannot be used as a previous statement for any purpose, whereas it can be used to contradict or corroborate. Come to question number 143. If two or more courts not subordinate to the same high court have taken cognizance of the same offence and a question arises as to which of them ought to inquire, the question is to be decided by whom? It is to be decided by the High Court within the local limits of whose appellate criminal jurisdiction the proceedings first commenced. Option B is the correct answer and it is mentioned under section 186 of CRPC. Question 144. Under section 198 of CRPC, no court can take cognizance of an offence against marriage punishable under chapter 20 of IPC unless a complaint is made by the police, the wife or husband, some person who is aggrieved by the offence, or all of the above. It is option C, some person who is aggrieved by the offence. Question 145. If it appears to the magistrate that the offence complained of is triable exclusively by the sessions court, he under section 202 of CRPC postponing the issue of process against the accused shall commit the case to sessions court, may direct an investigation to be made by a police officer, shall call upon the complainant to produce all the witnesses and examine them on oath, or shall return the complaint for presentation before the sessions court. It is option number C. Come to question number 146. In which of the following cases an error or omission in charge is not material? A is charged with cheating B and the manner in which he cheated B is not set out in the charge or is set out incorrectly. A defends himself, calls witnesses and gives his own account of transaction. Option B is A is charged with cheating B and the manner in which he cheated B is not set out in the charge. There were many transactions between A and B and A had no means of knowing to which of them the charge referred and offered no defense. Option C is both A and B and option D none of the above. The right answer is option number A and this is basically illustration B of section 215 of CRPC. Question number 147. Whenever a charge is altered or added to by the court after the trial has commenced, the prosecution has a right to recall or resummon any witness who has already been examined. The accused has no right to recall or resummon any witness who has already been examined. The prosecution has no right to call any further witnesses, or option D, all of the above. It is option A that the prosecution has a right to recall or resummon any witness. And it is which section? Section 217 of CRPC. Question 148. A is accused of an act that may amount to theft or receiving stolen property or criminal breach of trust or cheating. He is only charged with theft, but it appears that he committed the offence of criminal breach of trust. He may be acquitted, convicted to theft, convicted of criminal breach of trust, or discharged. He will be convicted of a criminal breach of trust. Section 221 of CRPC. Now question number 149. If the complainant is absent on the day fixed for the hearing of the warrant case, the magistrate may discharge the accused if the proceedings have been instituted upon the complaint. Option B, the offence is non-cognizable or compoundable, the charge has not been framed, or option D, all of the above. It is option D, all of the above. And which section? Section 249 of CRPC. Question 150. Under section 313 of CRPC, no oath shall be administered to the accused when he is examined. This is actually a repeat question and here the right answer is option number A. Question 151. Mark the incorrect statement. Section 319 of CRPC could not be invoked where the trial has not begun and no evidence has been recorded. Yes, this is correct. The power to proceed against a person not named as an accused is to be exercised sparingly and for compelling reasons. Correct. The provisions of section 319 of CRPC applies to all the courts including the sessions court. Correct. So the right answer is what? None of the above, because all statements are correct statements. Question 152. When the person who would otherwise be competent to compound an offence under section 320 of CRPC is dead, then the offence cannot be compounded. Offence can be compounded by any of the eyewitnesses. Legal representative of such person can compound the offence without the consent of the court. Legal representative of such person can compound the offence with the consent of the court. It is option number D. With the consent of the court, legal representative can compound the offence. And this is also a repeated question. It is mentioned under section 320. Question 153. Whenever a magistrate is of the opinion after hearing the evidence for prosecution and the accused that the accused is guilty and that he ought to receive a severe punishment, then such magistrate is empowered to inflict. The magistrate may forward the case to whom? You can forward the case to CJM, Chief Judicial Magistrate, and this is in which section? Section 325. This question was again asked in the year 2011. Question 154. When can a trial court release an accused on bail under section 389(3) of the CRPC after conviction, where an accused is on bail and imprisonment is not exceeding 3 years? Option A is the correct answer, not exceeding 3 years. Question 155. Assertion is that a bail, not jail, is the general rule in bailable offence in India. Reason: personal liberty is the most cherished right of the human being. So both these statements are true individually, and R is the correct explanation of A. Option A is the correct answer. Question 156. You have to match both the lists: summary trial, bail, search warrant, judgment. Summary trial means what? It is speedy disposal of petty cases. A का 4. Bail is release from the prison. So B का 1. Search warrant is a written authority to a police officer, and judgment is a conviction or acquittal. So the right answer here will be option number D. Question 157. The liability of a surety under the surety bond is what? Mutually exclusive of the liability of the accused under his personal bond, contingent on the liability of the accused under his personal bond, limited to the amount of the surety bond, both A and C. It is option D, both A and C. This is actually a conceptual based question. Come to next question, question 158. In computing the period of limitation, the time during which any person has been prosecuting with due diligence another prosecution in any court against the offender shall be excluded. The period during which the offender is absent from India shall be excluded. The period during which an offender is absconding or concealing himself is excluded, or all of the above. It should be all of the above. And it is mentioned where? Computing of period of limitation under section 470 of CRPC as well as section 15 of Limitation Act. Question 159. In a joint trial where several accused persons are being tried, one accused examines himself as a witness. Now, here the right answer is option number C, that only that co-accused has a right to cross-examine the accused, examining himself as a witness against whom such an accused has deposed something. Question 160. Period of limitation shall commence from the date of the offence, generally from the date of knowledge of the commission of the offence, if not known earlier, from the date of establishment of the identity of the accused, if not known at the time of commission of the offence, or all of the above. It is all of the above. And period of limitation mentioned where? 469 of CRPC. Question 161. Consider the following statements with regard to uberrima fides. It falls within the class of cases which require utmost good faith. Yes. Every contract is a contract uberrima fides. No, it is not necessary. And statement 3 is contract of insurance is an example of uberrima fides. Yes, correct. So the right answer is option number B. 1 and 3 are correct. Now question 162. A by a letter offers to sell his car to B for rupees 75,000. At the same time, B by a letter which crosses the above letter while in post offers to buy the car for rupees 75,000. In this context, which one of the following preposition is correct? This question is basically related to cross offer. Okay, this is an illustration of cross offer. So read out the options. That A contract is concluded when these two letters cross each other in post. A contract is concluded when the letter is posted by A reaches B. No contract is concluded at any time. A contract is concluded only when the letter posted by B reaches A. Here the right answer is option number C. No contract is concluded at any time. Question 163. X duly posts a letter of acceptance to Y, but the letter is lost in transit by negligence of the post office. There is no contract concluded because the acceptance has not reached the proposer. There is no contract concluded because the proposer had not received the letter. The contract is concluded because the acceptance is complete from the date of dispatch, notwithstanding any delay or miscarriage in its arrival from causes not within the acceptor's control, or none of the above. The right answer is option number C. And which section? Section 4 of Contract Act, which talks about acceptance. Question 164. A, in an offer to sell a property, gave B the right to accept within 14 days. The next day at about 3:50 p.m., B sent by post his letter of acceptance, which was received by A's office at 8:30 p.m. But before that, at about 1 p.m., A had posted a letter revoking his offer. The revocation and acceptance crossed in the course of post. B received the letter of revocation at 5:30 p.m. So revocation has been effectively made, has not been effectively made. In case it is a case of cross offer, so no contract can be said to be concluded, or none of the above. Here the right answer is option B. Revocation has not been effectively made, and revocation is mentioned where? Under section 5 of Contract Act. Question 165. Consideration is what? A motive for any promise, a price for any promise, only a moral obligation, something of value in the eye of law. This is a conceptual question of Contract Act, and here the right answer will be consideration is price for any promise or something of value in the eye of law. So right answer is option number C. 2 and 4 are correct statement. Question 166. A daughter promises to give maintenance to her uncle in consideration of her mother making a gift of certain properties to her. The daughter pleads lack of consideration when the uncle seeks to enforce the contract. She says that the uncle is a stranger to the consideration, so he cannot enforce the contract. Here the daughter will succeed because the uncle, being a stranger to the consideration, cannot enforce it, or will not succeed because the uncle is a near relation, and in such cases consideration is not necessary. And option C, cannot succeed because according to Indian Contract Act, consideration might move from any person. So in Indian Contract Act there is no privity of contract, so option C is the correct answer. And this question is basically a case. The case name is Chinnaiya versus Ramayya. Correct answer option number C. Question 167. The mother owes rupees 10,000 to her daughter, but the Limitation Act has barred this debt. The mother signs a written promise to pay rupees 3,000 on account of the debt. In this case, which one of the following is the correct? There is no contract as the debt is already barred by limitation, so it cannot be revived by subsequent promise. There is no contract because the mother has promised to give only part of the debt. This is a contract because there is a natural love and affection relation and the promise is in writing and signed. Option D is this is enforceable against the mother because such a promise is valid and binding under the Indian Contract Act. There is natural love and affection. It is basically exception to section 25 of Contract Act, right? And option D is also correct. So C and D both are correct. Now come to next question. Question 168. Which one of the following does not amount to fraud? Fraud. Section 17 Contract Act. Option A. Suggestion as a fact of that which is not true by one who does not believe it to be true. Option B. Active concealment of fact. Option C. A representation made without knowing it to be false, honestly believing it to be true. And option D. A promise without any intention of performing it. So not fraud is option number C. Question 169. A offers to sell B a painting which A knows is a copy of the well-known masterpiece. B, thinking that the painting is an original one and that A must be unaware of this, accepts A's offer. The contract is invalid. The contract is valid one because a unilateral mistake will not make a contract invalid. The contract is valid because there is no misrepresentation or none of the above. Here the contract is valid one. Option B is the correct answer. But now come to question number 170. Which of the following is not an agreement to restraint of trade? Agreement in restraint of trade is in which section? Section 27 of Contract Act. And see the options. Statement first says that A sells the goodwill of his business with an agreement not to carry on a similar business within specified local limits so long as the buyer carries on a similar business. A sells the goodwill of his business with an agreement not to carry on a similar business within India so long as the buyer carries on a similar business. Option C is A sells the goodwill of his business with an agreement not to practice the same trade for 25 years. Or statement 4 says that A sells the goodwill of his business with an agreement not to engage in any business competing or liable to compete in any way with the business for the time being carried on by the buyer. Here the right answer is what? Statement first and third. Now question number 171. A promises to paint a picture for B by a certain day at a certain price. A dies before the day. The agreement does not lapse and can be confirmed by or against legal representative of A. The agreement becomes voidable at option of A's legal representatives. The agreement lapses for both the parties or agreement becomes unlawful. Here the right answer is option number C and it is section 37 of Contract Act. Question 172. X agreed to supply 1000 tons of iron at rupees 100 per ton to Y to be delivered not later than 31st of January 2002. X also entered into a contract with A for purchase of 1000 tons of iron at rupees 80 per ton, telling A clearly that the iron is needed before 31st January 2002 for supply to Y to fulfill the contract with Y. A fails to supply the iron to X, who in turn failed to supply the same to Y. In an action by X against A, X can recover damages for the loss or profit he would have earned by timely supply to Y and also the damages which X might have paid to Y on account of breach of contract. Option B is the correct answer and this is actually illustration J of section 73 of Contract Act. Now come to question 173. Which of the following statement is correct? A voidable contract is an agreement which is enforceable by law at the option of one or more parties thereto but not at the option of the other or others. Option C is the correct answer and this is the definition of a voidable contract which is mentioned in section 2 clause I of Contract Act and this is also repeated question of 2014. Question 174. A landlord in good faith let out his premises to a young widow on a rent of rupees 1400 per month. Later on, he came to know that the widow was using the premises to carry on prostitution. In a suit by the landlord for recovery of rent, the court should do what? Should not reject the claim as the landlord had no knowledge of the purpose for which the widow was to use the let out premises. Option B is the correct answer. Question 175. A owes B rupees 3000, C pays to B rupees 2000 and B accepts it in satisfaction of his claim against A. This payment is a discharge of the entire claim. Option B is the correct answer and this is which section? Section 63 of Contract Act. Question 176. If a notice at the entrance of an automatic car park is an offer, it can be accepted by driving in. Option C is the correct answer. Question 177. Consider the following statements. If a person who finds goods belonging to another takes them into his custody, then he can pledge the goods, can gift the goods, is subject to the same responsibility as bailee. Subject to the same responsibility as bailee. And it is mentioned where? Under section 71 of Contract Act. Right answer is option number C only. Question 178. The defendant's husband agreed to pay rupees 400 per month to his plaintiff wife in consideration of her giving up prosecution against him under section 494 of IPC. An offence compoundable with the leave of the court. With the leave of the court, the offence was compounded and the husband was acquitted. In an action by the wife to enforce the agreement, the husband contends that the agreement is one to stifle prosecution and hence unlawful. In the light of above, which statement is correct? Now see the option D, that the wife can enforce the agreement against husband as agreement is not one for stifling prosecution as the offence is one compoundable with the permission of the court and has been so compounded. Option D is the correct answer. Come to question 179. J, a usual customer of B, orders certain goods on the day on which the B transfers his business to the plaintiff. The plaintiff accepts the order and supplies the goods. Thereupon J refuses to pay to allege that he has intended to contract only with B since he is having set off against him. Option A has no liability to pay the price because he has never intended to contract with the plaintiff. Right answer is option number A only. He never intended to do so, but here he has the duty to return the goods. Okay. Now question 180. A, B and C jointly promise to pay rupees 300 to P. P files a suit to recover the amount. Which of the following statement is correct? See the statements. C, that since A, B and C are joint promisor, P can recover the amount from any one of them. C is the correct answer, and this is actually section 43, illustration A of Contract Act. Question 181. 5 persons went to the house of Z armed with clubs to beat Z. Among these, 1A was carrying a pistol, concealing it underneath his clothes. During the beating, A fired a shot resulting in Z's death. Here, only A will be liable for causing death. Option A is the correct answer. And this whole question is an example of unlawful assembly. Now come to question number 182. Which one of the following is not correct in case of defense of intoxication? Intoxication is mentioned where? Under section 85 and 86 of IPC. Defense of intoxication is available both in case of involuntary and voluntary intoxication. Option A is the correct answer. Because here you have to tell not the correct statement. So first option A is not the correct statement because intoxication is available only in the case of involuntary intoxication. All other statements are true and correct. Now come to question number 183. A is in the house which is on fire with Z, a child. People below hold out a blanket. A drops the child in good faith, intending for the child benefit, but the child is killed by the fall. Here A has committed murder, culpable homicide not amounting to murder, culpable homicide as an exception to section 300 of IPC, or no offense. It is no offense, and this is actually
illustration D of section 92.
Question 184. A armed with a sword is at a distance from B. A threatened to kill B. B shot at A and killed him. Here B could plead private defense as he has a reasonable apprehension of being attacked by A's sword. B could not plead private defense as it cannot be said that he has a present and reasonable apprehension of being attacked by A. Right answer is option number B. Question 185. A instigates his 6-year-old daughter B to take away from C a purse containing rupees 1500. In this case, which one of the following statement is correct? B has committed theft and A abets theft. A commits no offense but B commits theft. Both A and B commit no offense. B does not commit any offense but A commits abatement of theft. Here right answer is option number D because B is his 6-year-old daughter, less than 7 years, so no offense, and A commits abatement of theft. And this is also a repeated question of 2015. Question 186. A, B and C decide amongst themselves to persuade D to steal jewelry from the house of M and they accordingly do so. D readily agrees and sets out towards M's house in order to steal jewelry. Here A, B, C and D will be liable for what? Criminal conspiracy. Option B is the correct answer. And criminal conspiracy is mentioned where? Under section 120A of IPC. Question 187. A person is said to give false evidence if he...
Answer is D, all of the above.
False evidence is mentioned where? Under section 191 of IPC. Question 188. A tries to pickpocket B B has a loaded pistol in his pocket. A's hand touches the pistol and triggers it, resulting in the death of B. Here A is guilty of what? A will be guilty only of pickpocketing. Option D is the correct answer. Question 189. A was relieved of his wristwatch worth ₹100 by B in a running train when the train was about to stop at a railway station. A raised an alarm. At this point of time, C pushed A, as a result of which A fell down and sustained injuries. This was done by C to enable B to carry the stolen watch. C has committed the offence of what? Has committed the offence of robbery, and robbery is mentioned where? Under section 390 of IPC. Question 190. X applied for the post of lecturer at Delhi University and submitted his application along with the degree of PhD. Interview call was issued to X and 2nd February 1992 was the date fixed for the interview of X. But on 10th January 92, the university came to know that the copy of the degree attached with the application was bogus and cancelled the interview. Here X will be guilty of what? Will be guilty of attempt to cheat. Option B is the correct answer. Come to question 191. In which of the following cases the offence of housebreaking is not committed? Housebreaking is in which section? Section 445 of IPC. Now see the option D, where a hole was made by burglars in the wall of the house but their way was blocked by beams on the other side. So housebreaking could not become possible. Option D is the correct answer. Come to question number 192. A person commits adultery. Adultery with section? Section 497 of IPC. If he has sexual intercourse with a person who is and whom he knows or has a reason to believe to be the wife of another man without the consent or connivance of that man, such sexual intercourse not amount to rape. Option A is the correct answer. Then it becomes adultery, not rape. Come to question 193. State in which of the following cases P is guilty of attempting to commit the offence. P, in order to forge a document purporting to be executed by Q, sends his servant to buy a stamp paper in name of Q. As the servant reaches stamp shop, he is arrested. Option B is P shoots at Q, whose back is towards him. The attempt fails as Q is beyond the range of the gun. Here P shoots but attempt failed, so he is guilty of attempting to commit an offence. Option B is the correct answer. Question 194. 6 persons assembled on a platform of Mumbai railway station and started fighting with each other. The passengers present at railway station got annoyed and felt disturbed. The public reported the matter to the police. These 6 guilty of. Come to question number 195. X, a person above age of 18 years, asks Y to shoot him to death as X is suffering from an incurable disease. Y is the domestic servant of X. As a loyal servant, Y shoots X to death. In the context of the above, which one of these statements is correct? Y has committed no offence. Y can take up the defense of good faith. Y can take up the defense of consent. Y's act is culpable homicide not amounting to murder. It is option number D, culpable homicide not amounting to murder, and this is what? Exception 5 to murder. 300. Come to question number 196. A is a good swimmer. He sees B drowning but does not save him. B is drowned. A has committed no offence. Here it is not the duty of A to save anyone, and what he did is a moral wrong and not an illegal act. So no offence. Come to question 197. A foreigner stabbed B, another foreigner, in a foreign vessel on the high seas. Both A and B were brought to Bombay for treatment, where B died. A is also available in Bombay. Which of the following propositions is correct in respect of applicability of IPC to the trial of A? As both the deceased and the accused belong to foreign countries and the occurrence of the offence has taken place on high seas, IPC is not applicable to A and hence he cannot be prosecuted in India. Option A is the correct answer. Come to question number 198. Assertion: there is no liability for an attempt to commit an impossible theft. Reasoning is no criminal liability can be incurred under section 511 of IPC for an attempt to be an act which, if done, will not be an offence. Here A statement is false but R is true. Option D is the correct answer. Come to question number 199. A is invited by B for a cup of tea while B is in the kitchen preparing tea. A finds a golden ring on the table. He picks it up and places it somewhere in the room with the intention of dishonestly taking it away sometime later. A commits what? A commits the offense of theft. A theft is in which section? Section 378 of IPC. Question 200. X and Y swimming in the sea after a shipwreck got hold of the plank. The plank was not large enough to support both. X, with no other option, pushed Y, who was drowned. X has committed murder, and this is related to section 81, which is doctrine of necessity, which can be applied here. So he will be committed for the offense of murder. With this, our 200 questions are completed. In case of any doubt, you can always write in the comment section given below. I hope you like this video, and if you like this video, then hit the like button and subscribe to our channel Law and GK. Thank you very much.